This court in Sayyid Abdul Qadir versus State of Bihar Supra held as follows: colon. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to. Full stop. It would not be out of place to mention here that the finance department had, in its counter affidavit, admitted that it was a bona fide mistake on their part. Full stop. The excess payment made was the result of wrong interpretation of the rule that was applicable to them, for which the appellants cannot be held responsible. Full stop. Rather, the whole confusion was because of inaction, negligence and carelessness of the officials concerned of the government of Bihar. Full stop. Paragraph. Learned counsel appearing on behalf of the appellant teachers submitted that majority of the beneficiaries have either retired or are on the verge of it. Full stop. Keeping in view the peculiar facts and circumstances of the case at hand, and to avoid any hardship to the appellant teachers, we are of the view that no recovery of the amount that has been paid in excess to the appellant teachers should be made. Full stop. Promised on the legal proposition considered above, namely, whether on the touchstone of equity and arbitrariness, the extract of the judgment reproduced above, culls out yet another consideration, which would make the process of recovery iniquitous and arbitrary. Full stop. Paragraph. It is apparent from the conclusions drawn in Sayyid Abdul Qadir's case, Supra, that recovery of excess payments, made from employees who have retired from service, or are close to their retirement, would entail extremely harsh consequences outweighing the monetary gains by the employer. Full stop. Paragraph. It cannot be forgotten, that a retired employee or an employee about to retire, is a class apart from those who have sufficient service to their credit, before their retirement. Full stop. Needless to mention, that at retirement, an employee is past his youth, his needs are far in excess of what they were when he was younger. Full stop. Despite that, his earnings have substantially dwindled. Full stop. Keeping the aforesaid circumstances in mind, we are satisfied that recovery would be iniquitous and arbitrary, if it is sought to be made after the date of retirement, or soon before retirement. Full stop. A period within 1 year from the date of superannuation should be treated as iniquitous. As such, Mr. Prem Singh, Land Council for the appellant, contended that the previous scale of rupees 220 to 550 to which the appellant was entitled became rupees 700 to 1600, since the appellant had been granted that scale of pay in relaxation of the educational qualification. Full stop. The High Court was, therefore, not right in dismissing the writ petition, full stop. We do not find any force in this contention, full stop. It is seen that the government, in consultation with the University Grants Commission, had revised the pay scale of a librarian working in the colleges to rupees 700 to 1600, but they insisted upon the minimum educational qualification of first or second class MA, MSc, MCom plus a first or second class BA LLB science or a diploma in library science, full stop.